All right, so in this lesson, we're going to start by talking about the Second Amendment, and then we're going to talk a little bit about the Fourth, Fifth, and Sixth Amendments. So the Second Amendment says, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. So the Second Amendment is going to protect an individual's right to possess weapons for their own defense. However, it's important to keep in mind that it says a well-regulated militia because the Second Amendment is historically going to be interpreted as applying to the militia. So the Supreme Court did not rule directly on laws that prohibit personal firearms or possession of personal firearms until 2008. So we're going to look at a couple of cases dealing with the Second Amendment and the right to bear arms. So the first one is the District of Columbia v. Heller, and this took place in 2008. So at this time, provisions of the DC Code are going to make it illegal to carry an unregistered firearm and prohibited the registration of handguns. So at this time, only the chief of police could issue a 1-year license for handguns. So Dick Heller was a DC police officer that was authorized to carry a handgun while he was on duty. He's going to apply for a 1-year license for a handgun that he wanted to keep at home, but it is going to be denied. Okay, so under that DC code. So Heller is going to sue DC, arguing that those codes violate his Second Amendment right to keep a functional firearm in his home without a license. So this is where this case doesn't necessarily make sense because he could carry a handgun for his job, but he wasn't allowed to have his own firearm at home, his own handgun at home. So the court is actually going to rule in Heller's favor. They're going to say that banning handguns, which is a class of arms commonly used for protection purposes, and prohibiting the firearms from being kept functional in the home, an area that was traditionally in need of protection, is going to violate that Second Amendment right to bear arms. So this case is going to be important when we get to McDonald v. Chicago, which is actually a case that you are required to know for the AP exam. Okay, so this one is going to stem from District of Columbia v. Heller. So after that case, several suits are going to be filed against Chicago challenging its gun bans. So a Chicago ordinance is actually going to ban the ownership of handguns. And Otis McDonald is a city resident who lives in a dangerous neighborhood. He had been the victim of crime in his home on several occasions. So he is going to sue the city of Chicago based on that Second Amendment right. So they are going to argue that the Second Amendment should also apply to the states. So the question here is, does that Second Amendment, that guarantee of the right to keep and bear arms, apply against infringement from state and local governments? So Chicago had that ordinance. So the question is, does this federal law, does it overtake or overpower that city law? So the court is going to rule that the right to bear arms is not any less important than the other amendments in the Bill of Rights, and that it's considered a fundamental right. So while states do have the authority to place reasonable restrictions on firearms, they cannot prohibit individuals from holding firearms because this is a constitutional guarantee. Okay, so the right to keep and bear arms has been extended to the states. All right, moving on, let's talk about the rights of defendants. So before we get into the Fourth, Fifth, and Sixth Amendment, it's important to know that before the Bill of Rights was actually added to the Constitution, that it did include some protections. So the first is that it prohibits ex post facto laws, and these are laws that criminalize conduct that was legal when it occurred. So ex post facto actually means after the fact, okay? So you can't make laws that criminalize a conduct when those crimes did not actually exist within the law before the action was committed. The second is that it prohibits bills of attainder, which punish individuals without a trial. So people cannot be declared guilty of crimes by legislative acts. And then the third one is that it establishes the right to demand a writ of habeas corpus, which is a document setting out the reasons for arrest or detention. Okay, so this is going to protect the right of a detained person to be brought before a judge and defend his or herself. All right, so those were included before the Bill of Rights. Now we're going to get into some of the other protections of the Bill of Rights. So starting with the Fourth Amendment. So the Fourth Amendment is going to include protections against search, seizure, warrant, and evidence. Okay, so it prohibits unreasonable searches or seizures and is going to require warrant based on probable cause. So that means that in order for a police officer or some other law enforcement agency to search your home or your property, there has to be reasonable suspicion that a crime has been committed or that there is evidence relative or relevant to a criminal investigation. Okay, so they have to have that warrant and they have to have it be based on probable cause. All right, now let's talk about the exclusionary rule. So under the exclusionary rule, and this is going to be established by Matt v. Ohio in 1961, evidence that is obtained without that warrant is not going to be admissible in court. So essentially, a warrant is permission to search someone's home or property. So Mapp is going to be convicted of possessing obscene materials after an admittedly illegal police search of her home. So they didn't have a warrant to go into her home. So she is going to appeal her conviction, okay, and the court is going to rule in her favor, okay? So in order for evidence to be used in court, it has to be obtained the correct way. So the court has also placed restrictions on the use of evidence involving technology, like invalidated use of thermal imaging and evidence obtained from cell phones without a warrant. All right, moving on to the Fifth Amendment. And the Fifth Amendment is going to cover lots of different protections. So it includes protections against double jeopardy and self-incrimination and guarantees due process. So when you think of double jeopardy, that means that you can't be tried for the same crime twice. Self-incrimination would be an example of saying, I plead the fifth, okay? So you're not going to be required to testify against yourself, okay, or self-incriminate yourself, and then guaranteeing that right to due process. So individuals that are suspected of having committed a serious crime must have an indictment handed down by a grand jury. And a grand jury isn't like a jury in a criminal case where they are going to decide if a person is guilty or not guilty, but the grand jury is going to decide whether or not there is actually enough evidence to take a defendant to trial. So again, the Fifth Amendment prohibits double jeopardy, which is the prosecution of an individual more than once for the same crime, so you can't be tried for the same crime twice. It protects against that self-incrimination, which means that an individual cannot be compelled to give testimony that might lead to criminal charges against them. So again, if you see on movies or in TV, I plead the fifth would be an example of that. And then there is the case of Miranda v. Arizona. So this is going to establish Miranda rights. So Ernesto Miranda is going to be arrested on suspicion of rape and kidnapping and interrogated for 2 hours. He confessed to the crime, and his confession was admitted as evidence at a trial where he was convicted. However, Miranda is going to argue on appeal that he did not know and was not informed that he had the right to remain silent or the right to counsel. So his confession was therefore coerced and could not be used against him. So the government is actually going to rule in his favor. Okay, so the government has to ensure that suspects in custody are aware of their rights before questioning in what has become known as that Miranda rule. So this is where you see on TV, and I always think of Law and Order SVU, where when a police officer or some kind of law enforcement agency is arresting a suspect, they will tell them that they have the right to remain silent and that anything that they say can be used against him or her in a court of law, and that they have a right to have an attorney present during questioning And if the suspect cannot afford an attorney, one will be appointed to him. All right, and moving on to the Sixth Amendment. So the Sixth Amendment guarantees defendants the right to a speedy trial, a fair jury, and an attorney. So this is, again, one of the required cases that you have to know for the AP exam. So make sure that you know the details for Gideon v. Wainwright. So Clarence Earl Gideon is going to be charged in Florida State Court with felony breaking and entering. Okay, so he is going to be charged with stealing a bottle of wine and money from a cash register in a pool hall. However, he is going to appear in court without a lawyer and request that the court appoint one for him. Okay, so he is too poor to hire an attorney and he wants one to be appointed for him. However, under that Florida state law, an attorney could only be appointed in capital cases, okay, so death penalty cases. So the court is not going to appoint one for Clarence Earl Gideon. So Gideon is going to represent himself in court, and he is going to be found guilty and sentenced to 5 years in prison for robbery. And he is going to appeal his conviction on that basis that he was denied counsel. Okay, so he's going to argue that the trial court's decision violated his constitutional right to be represented by an attorney. So the question here is, does the Sixth Amendment right to counsel, so having a lawyer, apply in all cases, even those that aren't involving a severe penalty? And does that right to counsel apply to these states? So the court is going to rule that it was consistent with the Constitution to require state courts to appoint attorneys for defendants who could not afford counsel on their own. So the right to counsel is a fundamental right and is essential to a fair trial and due process of law. So states have to provide appointed attorneys for poor defendants. All right, and that's where we're going to stop with this video.